Hi guys! Welcome to another episode of Attorney Vlogger, Law for the Everyday Layman. Today we take up assignment of credits and other incorporeal rights. If you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now let's begin with assignment of credits or other incorporeal rights. Now, what is an assignment? An assignment is a contract by virtue of which one person, known as the creditor or assigner, transfers to another, known as the assignee, his rights or actions against a third person, who is the debtor, in consideration of a price certain in money or its equivalent. In other words, there is a pre-existing relationship between the creditor and a debtor, and the creditor transfers or assigns his rights to an assignee, and that assignee can now enforce those rights or actions against the debtor. Between the creditor and the debtor, the assignee is a third person who is bound, and the debtor is now bound to respect the assignment. Okay? The assignee can now enforce the rights and actions against the debtor because of the assignment. While as between the creditor or assigner and the assignee, the debtor is the third person to that relationship. Okay? He must also now respect the assignment, and the assignee can now enforce the rights and actions against that debtor. Okay? Now, an assignment is consensual, it is bilateral, it is onerous, commutative, and aleatory. And an assignment is really a sale. Okay? In that the object or the subject matter is the credit or right which is assigned, and the consideration is the price paid therefore. In an assignment, the assignee merely steps into the shoes, okay, of the assigner. He acquires the credit subject to the defenses of the debtor, okay, like prescription, etc., no? And he is subrogated to all the rights or obligations of the seller, okay? Now, when I say that, even though the assignee steps into the shoes, he acquires the rights of the creditor, this means that the assignee cannot acquire a greater right than that which is passed to him by the assigner. Okay? And the assignment includes all of the accessory rights which may be attached. Okay? Like a guarantee, mortgage, pledge, etc. Okay? Now, in case of an assignment, the consent of the debtor is not necessary. Okay? But what is necessary is that notice must be given to the debtor that an assignment has been made. Why? Because if the debtor has no knowledge of the assignment and he pays the credit due to the creditor instead of the assignee, then the debtor is released from his obligation. Okay? So, in order to protect the rights of the assignee to claim the credit, there must be notice given to the debtor that an assignment has been made. Okay? In such a case, if the debtor is released because he has paid to the creditor because he did not have knowledge of the assignment, then the remedy of the assignee is simply to go after the assigner. Okay? Now, the assigner makes several warranties. No, actually, 2 warranties. No? The assigner in good faith warrants the existence and legality of the credit at the time of the sale. However, please take note, there is no warranty first if the credit was sold as doubtful, meaning it's doubtful that the assignee will be able to collect on it. Okay? And there is also no warranty as to the solvency of the debtor, whether the debtor is insolvent or not, except if it is expressly stipulated that he warrants the solvency of the debtor. Okay? Or if the insolvency was already existing and of public knowledge at the time of the assignment. Okay? So, in case there has been an express warranty by the creditor or assigner that the debtor is solvent, okay, if he has expressly warranted the solvency of the debtor, then the assigner's liability has a certain duration. Okay? If there is a stipulated period, then his liability on that warranty will only last for the stipulated period. But if there is no stipulated period, then there are two rules. The duration of the creditor or assigner's liability will be 1 year from the assignment when the period for the debtor's payment has expired. Okay, that's the first case. Or second, after 1 year from maturity if the period for payment has not yet expired. Okay? If the assigner in good faith violates the warranties, warranties on existence, legality, or solvency if expressly stipulated, if the assigner in good faith violates those warranties, then his liability only extends to the price, the expenses of the contract, and the other legitimate payments made by reason of the assignment, if any. But if the assigner is in bad faith, then meaning that he knows of the defects in any of those warranties, if the assigner is in bad faith, then he will not only be liable for those things I mentioned previously, price, expenses of contract, and other legitimate payments, but he will also be liable for damages. Okay? Now let's move on to another topic. In case of the sale of successional rights, this is an incorporeal right, meaning the inheritance, inheritance before partition. Again, just to be clear, inheritance is not what you have received from your lolo or lola who has died, okay? Inheritance is the mass of properties which the decedent or the person who died leaves behind, okay? Your successional right is what you will be receiving from that person, okay? So in case of a sale of successional rights, if there has been no specification or enumeration of the things which comprise that right, such as you stand to receive a car, a house, etc. If there has been no such enumeration, then what is transferred by the assigner is merely his character as an heir. In other words, he warrants only the facts of heirship, that he is an heir and that you are now getting his rights as such heir, okay? But that assigner is not warranting any objects that you will receive under the inheritance. Why? Because there has been no specification or enumeration. He's only warranting that you stand to receive something as an heir, okay? Now, the obligation to deliver that successional rights, of course, includes the obligation to deliver any of the fruits that will be produced, okay? So, the assigner or the seller has to necessarily deliver those fruits if he receives them to the assignee. In case the seller or the assigner consumes those fruits, okay, or he uses them, then he is bound to reimburse the assignee, okay, except if there is a stipulation to the contrary. Now, if the buyer, on the other hand, or the assignee, has also an obligation. He has to reimburse the seller or the assigner for the debts or charges on the estate which the assigner may have paid. Okay? So, those are the reciprocal obligations of the parties. Okay? Now, in case, instead of consuming the fruits, the assigner has sold the fruits to someone else, then his liability in that case is to give the price he has received to the assignee. Okay? Now, let's move on to another topic. Okay? What if there is a sale for lump sum of the whole, okay, whole of certain rights, rents, or products, okay? So, in case those things are sold as a whole, take note, as a whole, the subject here is the totality, okay? So, therefore, the assigner warrants only the legitimacy of the whole. He does not warrant each of the parts, okay? So if the assignee or the buyer is evicted from one of the parts, then there is no breach of warranty and he cannot hold the assigner liable. However, there is an exception. If the eviction takes place or involves either the whole, the buyer or assignee is evicted from the whole, or the greater part, the greater part of the rights transferred, then he can hold the assignor liable for breach of warranty. Okay, let's try to make it clear by giving an example. So let's say there's a partnership, okay? And A, B, C are partners, and C sells his share to X, okay? X, upon dissolution of the partnership, receives the share was sold the share of C was sold to X for 150,000 pesos, okay? And upon dissolution of the partnership, X was able to receive 50,000 pesos, some office equipment, and a car, okay? So those are what he received upon dissolution of the partnership. Okay, so in case there is a creditor outside, some other third person, a creditor recovers the car because he's the actual owner of the car, then there can be no breach of warranty there because the warranty as to the car is not warranted by the assigner, the assigner only warrants the whole. Okay, but if the value of the car is 75,000 pesos, then the assigner can be held liable for breach of warranty. Why? Because now the value of the car is greater than the rest, Because remember, the money is only 50,000. 75 is definitely more. And the remainder, the office equipment, is definitely less than 50 and 75 combined. So 75 is the greater value of the things, in which case the assigner can be held liable for the breach of warranty. Okay? The final topic under assignment of credit and other incorporeal rights is the right of legal redemption. I discussed legal redemption in one of my videos under the topic of sales, okay? And here, under assignment of credits, legal redemption can be exercised by the debtor, okay? By the debtor, in case of a sale or assignment to a third person of a credit or right or other incorporeal right which is under litigation. Okay? So, the requisites are as follows. First, there must be a sale or assignment of credit to an assignee, Second, that right or credit, must be pending litigation. Okay? Third, in order for there to be legal redemption, the debtor must pay the assignee the price of the assignment, the judicial costs, and the interests. Okay? And finally, the debtor must exercise the right of legal redemption within 30 days from the date that the assignee demanded payment. Okay? And the purpose of this article on legal redemption is to avoid the purchase by a third person merely for speculation. Now, this right of legal redemption does not apply in the following cases, okay? First is when the sale is to a co-heir or a co-owner. Okay? Why? Because this supports the policy of the law to do away with the co-ownership. If you will remember my discussions, the law does not favor co-ownership. And in this case, if the incorporeal right is sold to a co-heir or a co-owner, then that promotes the policy of the law because that is now unifying the mass of the property into a single or into less people who will now hold the property. Okay? Again, the law does not favor co-ownership. Next, the next case where legal redemption does not apply, in credits or incorporeal rights, is in case of a sale to a creditor in payment of a credit. Why? Because this is a lawful means of paying off the debt, In this case, the assignee is not considered the buyer, of a right in litigation, and he's not considered a buyer for purposes of speculation. Because remember, the purpose is to avoid speculative purchases. Okay? So here, the credit was purchased by the creditor. Okay? In payment of the credit. In such a case, legal redemption does not apply. And finally, the last case where legal redemption does not apply is in the case of a sale to a possessor of land subject to a right which is under litigation. Okay? Why? Because in this case, the assignee is moved by a desire to preserve the property and not to speculate. An example of this is where X has a loan with mortgage, secured by a mortgage from Y. Okay? And then X sells that land subject of mortgage to Z. Okay? And then Y, on the other hand, assigns his right to Z. So Z now owns both the land subject of the mortgage and the mortgage credit. In this case, if X wants to redeem the land, then he cannot redeem the land. Okay? Because it has been sold to the possessor of a land who which is subject to a right in litigation, in or under litigation. Okay? In such a case, Z is motivated by a desire to preserve and cultivate and improve the property because he has consolidated in himself both the ownership of the property and the mortgage credit. Okay? So that's it for assignment of credits, and I hope you may have picked up a thing or two. This topic is important both in relation to sales and in the upcoming videos which I will be releasing soon on negotiable instruments. Okay? Because there is a difference between assignment and negotiation. Okay? So I hope to see you soon, guys. Bye!